but you have to consume it on the premises, like a soda bottle. I call it the Slurpee rule. You buy a Slurpee, you do it, put it on the grocery bill. Okay, and she had her daughter's cell phone. I don't know why it's always the daughter's cell phone. She had to put some minutes on it. She charged the grocery bill. She wasn't going to use the minutes right then and there, so she technically violated the rule. And I got that one actually reversed by a circuit court. That one's going up on appeal to the Court of Appeals now. But the point is, what difference does it make to 7-Eleven whether she consumes it or not on the premises? They get paid for it exactly the same time, whether it's consumed on the premises or not. The next payroll is deducted from her pay. So again, just the fact that you violated a rule doesn't mean it's automatically deliberate, intentional, willful, work-related misconduct that's going to disqualify you. Next slide, mitigation. Okay, once the employer has proved misconduct, the burden shifts to the employee to prove that misconduct really wasn't that bad. A good example is the full of S case, Kennedy Speaker versus Cooper, or a recent case I had, the effing liar case, actual case, an employer that rhymes with Walmart, and this lady had been falsely accused 3 times of pushing a reshop basket to a part of the store that she shouldn't have been. So finally said to her manager, look at the tape, I didn't do it. So look at the tape, you didn't do it. So then she went and talked to the employee who had falsely accused her and just said, hi, how you doing? Fine, how you doing? Why do you say I'm pushing the cart up there when I'm not doing it? Well, Miss Deborah, I saw you do it with my own eyes. To which she said, well, you're a effing liar. That was misconduct. According to the deputy, I got that reversed by the appeals examiner because that was provocation. I mean, she'd been falsely accused over and over and over again. And yes, it was poor judgment to say you're an effing liar, but it was only to that employee. No supervisor overheard her, no customer overheard her, nothing like that. All those were circumstances that minimized the bad thing she did, the poor judgment she did. Next slide. Turning down suitable work. As was suggested earlier by the speakers, if you turn down suitable work, you won't get unemployment compensation. And suitable work means anything that you're able to do based on your past education experience, training, work history, even if it's less pay than you got before, as long as it's at least minimum wage, it's probably going to be considered suitable work. Even if it's going to be less money than you would get from unemployment compensation, it's probably going to be suitable work because you could always get partial unemployment compensation. If the money you're getting from a job is actually less than you would get from unemployment compensation benefits, that week, Virginia Employment Commission will make up the difference, which is called partial unemployment compensation.
What if it's a long drive?
If that's going to be transportation issues are a good issue. Probably, if you've got transportation, 20 miles is probably going to be reasonable. 50 miles, probably not. 75, almost definitely not. But if you don't have transportation, that can be, and your employer knows that, and you lose your job because of that, you will not necessarily be disqualified. I had a case very recently. A guy worked in Richmond for at least 5 years for this particular company. They were kind of a contractor. It was a glass company. They were in fact working on the federal court building right over there, diagonally across from us. That particular job ended, and they had no other work for him except in the shop, which had just moved from South Richmond down to Chester, 11 miles away. My guy lost his driver's license 10 years ago due to a DUI. He was getting to work either by public transportation or some supervisor was picking him up and bringing him to work. And that's how he was getting either to the shop in South Richmond or to the federal court building right across the street there. Once his job site moved to Chester, only 10 miles away, you can't get on the bus from here to Chester. He had no driver's license, he had no ride, he lost his job, he was disqualified, I got that reversed. So transportation is generally on the employee, but there can be circumstances where even bad transportation, lack of transportation, can be not disqualified. If you've got transportation, I'd say 20 miles is not unreasonable to drive. 50 75 probably. Next slide, actually just covers it. Looked at a lot of things to determine whether work is suitable, work history, fitness for the job, risk, distance from home, etc. Next statement, next slide, false statement. I think Carolyn mentioned this earlier. You've got to be honest with the VEC. And if you don't report stuff that you should report, or you give them inaccurate, false information, like you know you should be reporting your earnings, and you don't report your earnings, or you underreport them, and you do that intentionally, you're going to be disqualified for 1 full year. And there's a look-back period of 36 months. So if any time in the past 36 months you get a false statement, you're going to be disqualified for 1 full year. This time, guy who came in with that, and I said, "That's it. You knew you should have. You admitted you should have." In his appeal, he said, "I know I did wrong." I said, "You admitted it. You're disqualified for a year." There's just nothing I can do about that. And the final slide, I've got incarceration. I think more and more of these cases. This is a special provision of the law. Is if your separation from employment arose as a result, this is from the statute, of an unlawful act which resulted in a conviction, and after your release from prison or jail, so you purge the disqualification. So in other words, you're arrested, you're jailed, you're convicted, and because of that, you lose your job. Even though you or your husband, wife, boyfriend, girlfriend called your job and told them, I've got a problem here, can't go to work, I'm in jail, that's going to be a disqualification. Now, if you're not convicted and you made those reports, then you didn't lose your job because of an arrest and jailing and conviction. But if you lost your job because you were arrested, jailed, and ultimately convicted of that unlawful act, you be automatically disqualified for unemployment compensation. That covers mine.